All right, I'm excited about this one. Like we said, we're talking about how Genius Act can, or what the implications of the Genius Act are for AML and privacy. And I'm up here with three people much smarter than me. So just to start off, I'm wondering if you guys can each introduce yourselves and in brief, maybe like 2-3 minutes, just kind of explain the work that you're currently doing on this topic to kind of get everybody up to speed.
Sure. So good afternoon. My name is Ross Schulman. I'm with Spruce ID, which is a company that develops identity solutions mainly right now for state governments, so including California, Colorado, and Utah. And personally, I'm actually working for most of the pertinent stuff related to what we're talking about today on our response to the Treasury's RFI and just kind of thinking about how digital identity and public policy intersect.
Okay, so I'm Ian Miers. I am a professor of computer science at the University of Maryland. More relevantly for this audience, I was a co-inventor of Zcash. So that came out of my PhD thesis. The other thing that came out of that, thank you, though for the feds in the room, I had nothing to do with it, was Tornado Cash and every other major privacy-preserving protocol except Monero. Sore point there. Then did a bunch of work on the foundations for decentralized anonymous credentials back in 2014, believe it or not. Privacy-preserving smart contracts, so the stuff underpinning Alio and Aztec was a paper we wrote. I'm an advisor to Alio. And these days I've been working on anonymous reputation and programmable identity on the academic side, which is a tool that I think will be quite relevant for these kind of problems.
Hi, I'm Laz Piper. I'm the research director of the DeFi Education Fund. We are a nonprofit advocacy group here in DC. Basically, what we're working on in regarding the digital identity topic under the Genius Act is digital identity verification in smart contracts, and so we'll be submitting a comment letter tomorrow. Pursuant to that.
Awesome. And I guess I should contextualize a little bit who I am, because independent journalist probably doesn't mean anything to the people in this room. But yeah, I am a freelance reporter. I was most recently at Unchained covering crypto policy and regulation. Before that, I was at Forbes and at a publication called Protocol. And I report on these types of things. So like Ross kind of hinted at, the main topic, or like I guess the subtopic for this panel is this Treasury Department request for information, or RFI, that was put out on August 18th. And it asked members of the public to provide input on innovative or novel methods, techniques, or strategies to detect and mitigate illicit finance risks involving digital assets. Specifically asked for information about APIs, artificial intelligence, digital identity verification, and blockchain technology. And where this connects to the Genius Act is this was requested in the Genius Act. The language is almost exactly the same, and it asked Treasury to launch some research into these topics within 30 days of the bill being passed. So just to start, can one of you kind of catch us up on like why is this part of the Genius Act? Because it's not specifically about stablecoins. So how did we end up here? Maybe Laz is good to talk about this? Yeah,
sure. So basically, in the Genius Act under Section 109, the act basically requests that Treasury does a RFC, a request for comment, on a variety of technological approaches to mitigating illicit activity risk in the digital asset ecosystem. Basically, it's just been an appetite in Washington, as you can imagine and have seen. And so they kind of just wanted a better understanding of what works, what doesn't work, what are the risks. And like the second part of that section actually asks Treasury to write a report on the various risks, including privacy.
And like you said, there's been an appetite for this. There's obviously been a lot of talk about this in Washington, but if you're taking a skeptical angle, there's also this question of like how much of it is lip service? How much of this is actually like genuine interest in going to go somewhere? Maybe we can just go down the line. Like how much potential do you actually think there is here to get the government to change how it considers digital identity, how it thinks about AML, KYC? Just to kind of help us understand the table stakes here.
So I think I think the answer to that is more than we've seen than in my memory, at least. I think the flip side of that is that we're still talking about the federal government here, so things may still move incredibly slowly, even though this is the sort of the most movement that we have seen in, I don't know, 20, 30 years or something on financial privacy.
For folks that are not government folks, like, what do you mean by incredibly slowly? Like, what is incredibly slowly by government standards versus for this private sector?
I mean, it's entirely possible that Treasury could get in the results of this RFC and do nothing with it, right? I mean, they're not under any legislative requirements at this point to do anything further other beyond the sort of call for information that Laz mentioned. So they could just shove it in a drawer somewhere and say thank you very much. They do have requirements to do other rulemaking pursuant to Genius Act, but my understanding is not about that. They don't have any requirements to do so about the financial privacy questions that were posed in the RFI. What slow could mean, it could be anywhere from 18 months to a decade, like who knows, right? It's sort of, there's no obligation for them to do anything other than the pressure that we, the people, put on them, so.
Ian?
There has always been some interest from folks at FinCEN in alternative means of doing KYC and identity. They've always wanted people to come up with ideas. There haven't been ideas for the most part, and there wasn't political will from the top down, and there were other parts of Treasury that were not interested in that. To some degree, it seems like this has changed. But I'm a computer science professor, not a political science professor, and I don't hang out in those bars in DC, even though I do live here. So my opinion on this is worth exactly zero.
I don't think I could add much more than Ross. I think he had a pretty good answer. I will say that it's good that there is an RFC, though. It's like a very democratic process and get public input, which I advise all of you, if you can submit by tomorrow, to say something. So that's always a positive thing.
And just so we understand the process here, like literally what happens next? Is it possible that they just get all these responses, all these comment letters, and do nothing from there? Or do they have to produce some kind of report sharing, how they interpreted these responses? Sounds like you want to... So
they do have to produce a report for Congress under the same part of the Genius Act that told them to do the RFC. I don't believe the bill goes into any more detail about what needs to be in that report, but what usually happens, inside of an agency kind of in response to this is that, staffers will take each submission sent in by the public. Usually they'll chop it up into sort of, subject matter pieces and farm them out to the various kind of people who are going to be going over it, and they'll go through and read they'll read responses, and then they'll synthesize kind of what they have learned into this report that they'll send on to Congress. Okay,
and then let's talk about what you guys are actually commenting. What Treasury might be actually reading through. Like Laz said, the deadline is tomorrow. My understanding is that deadline is often a little flexible too. We might see more. But last I checked, there were 114 comments submitted, and I don't think any of you guys had submitted yet. So I'm wondering if you can give us a little preview about just the outline of what your comment letters say and what you're going to recommend. Can we start with Laz?
Yeah. So, we take we really advocate for privacy in this space, and interestingly, the section that asks Treasury to do this RFC only asks them to look into technologies that financial institutions can use. But when you read the RFC, they actually mention smart digital identity verification in smart contracts, which is not a financial institution, it's just software. And so that basically requires us to say something, because that is what we advocate for, is just decentralized finance. So for us, we answer a couple of things. First, they do ask, what are the trends and what are responses to mitigating risk or illicit activity risk in the digital asset ecosystem. And we found, which I think a lot of people can attest to this, that it's fundamentally a cybersecurity issue. We need very strong development of DeFi protocols. I think hacks are not just in DeFi, but even in traditional finance, are pretty fundamental to illicit activity. And so, there's like the Security Alliance, which we really like. There's like ImmuneFi, which is like they broker like relationships between security researchers and protocols so that people's code is audited. And so, we think like there should be an appetite in federal government to really work with like the cybersecurity sector and make sure that this stuff is secure. And then the second part of that, we do touch on like the digital identity verification. It is an evolving technology. And so we really want Treasury to consider all the risks that arise from this evolving technology. The panel on like the dystopian aspect of it, I think they really nailed it on a lot of different factors. But we also include one factor that I feel like isn't talked about enough, but on like the issuer side, like there still needs to be a source of truth that's signing off on your credentials. And whether that's a federal agency or like a government authorized entity, like it's currently US policy that they retain all the information you submit to them. And as we all know, that's like created these massive central repositories known as honeypots that have been the target of hacks for as long as we've known. And a lot of that is like very sensitive information, American sensitive information. I'm sure you guys can remember the 2017 Equifax hack that basically took like half of Americans' information. And so we want Treasury to slow down, consider the risks here, and also allow like technologists to evolve and build things that are very privacy enhancing. I think there's a lot of good work being done out there that's like tackling it step by step. Like the last panel hit on this too. It's like, you have zero knowledge proofs, but now you have MPC, and it's just like you keep going down the line until we can get probably to a more secure place. I'm not necessarily like a doomer by any means. I think that technology is good, but it should be built responsibly, and allow people to build responsibly then, and to build safe technology for people to use. Because, I know identities have many use cases. They're going to inevitably evolve, so.
And Ian, you're not writing a comment, right?
No, I can go last because I explained some other comment with a co-author of mine who I let him volunteer to do the hard work to translate into a thing.
Cool. So we'll circle back. Ross?
Sure. So, being a digital identity company, we've sort of have come at this RFC with that kind of hat on. So, and I think, our response kind of runs a range from some really kind of low-hanging near-term fruit that could be really make everybody's life just a little bit easier, which should be sort of, okay, when a bank or brokerage or whatever is doing Know Your Customer, maybe we should be able to use a mobile driver's license instead of actually having to take a picture of our license and send that in and yada, yada. So that's kind of, I think, relatively uncontroversial and would be great to have, So that's sort of like this far end. And at the other far end, I think there's an opportunity now to actually kind of more radically rethink how the KYC / AML system works in our current or how it works now. Rethink that. And move more toward a system where, every single bank and brokerage has to do their own KYC, to a system where maybe you have a trusted party. I think we use the term identity trust in the submission, but where that party can do the KYC work and issue digital credentials to the individual that you could then present to any bank or any brokerage that you wanted to work with. The technical details are sort of, you can read our submission if you want to, but it's sort of a system where we can use the zero knowledge or multi-party computation techniques that the previous panels had been discussing to get better privacy for individuals who are engaging with the financial system, more access to financial flows by regulators and investigators, but only in situations where they have gone through a legal process of some sort that would obviously have to be defined in law and so forth. So there's like a lot of room for interesting kind of future thinking. And again, this is the sort of thing where it's not going to happen next week or maybe even next year, but we have an opportunity here to sort of paint a picture to give regulators and legislators an idea of what the technology is capable of producing.
Sure. I mean, yeah, the chance to get heard out is definitely valuable, whether it yields anything immediately or not. Ian, I said I'd come back to you.
Yeah. So, friend of mine, Peter van Valkenburg, who's the director at Coin Center, and I wrote a paper, something, Tear Down This Wall, it's got a very long name, on how to do better privacy-preserving KYC. And he's submitting a comment based on that. Luckily, I don't have to stay up writing it. And it hits a lot of the same points here that you all mentioned, but the key point is you really have to rethink this. You can't give someone your identity information or even prove something about it, because that actually doesn't work. A proof that you're not a North Korean now is not very useful in 5 minutes. To go back to a system where you keep all your data, and we have a way of doing sort of dynamic risk scoring where you can verify or compute how risky you are on an updated basis and send that attestation to various parties. And the reason you need to do that kind of a system is anything you build where you end up with a central repository of data, whether it's in the hands of the government or third party, or even you do some fancy cryptography to secret share it between 3 people. Hint, if you hear a pitch for that, it's never 3 people, it's one guy in a trench coat pretending to be 3 subsidiaries. If you do that, that data will get stolen. So you mentioned the Equifax breach. Do you know the thing that happened before that involved the same actors? Okay, so who here lost their data in the OPM breach? Okay, so we have a couple of people who have security clearances. So hackers, the U.S. accused and I believe indicted in the Ministry of State Security, compromised the Office of Personnel Management database, which keeps security clearance applications. Then a couple of years later, they went and stole the Equifax database. So now you have a list of people with sensitive TSSCI clearances and people who are not good with their money. By the way, security clearances at least were only renewed every 5 years, so there's a nice gap between when you got it and when you could get into debt. So this kind of data is a massive national security problem, and you don't want to put it in one place. So you need to design systems that don't do that. Other than that, same points everyone else said.
I want to go back to you because I'm going to use you as kind of like chief skeptic on the panel. Are there any proposals that have been made either formally in response to this RFI or informally, on Twitter, in white papers or blogs, or even earlier today that you think are like not actually feasible in practice, like technologically? Obviously, this
not
is where
entire. I think actually the problem is that people miss the game we're playing. So a lot of the suggestions I've heard are static things. Prove at this time I am not a North Korean. Prove I have a US passport. Prove whatever. None of the history of computer attack and defense or anti-money laundering is a static system. You have to be able to react and adapt, because any given tactic you pick, they're going to adapt their tactics, techniques, and procedures to get around it. That's reality. It's a cat and mouse game. That's the game that FinCEN plays. That's how they go to banks and say, look, your AML flags aren't up to date. You need to update them. And that dynamic, from what I've seen, and I will caveat this with, I was not here this morning. I have deliberately not read anyone else's proposals to Treasury because I don't care. Missed that. So apologies if I'm throwing someone's work under the bus that I didn't read, but nobody seems to realize you need this. And that, I think, makes a lot of these moot. I think the thing you'll likely get out of this rulemaking, sort of no doubt, is banks can take verifiable credentials. But what they would do is they would take a verifiable version of your driver's license, and they would save that verifiable copy. So when it gets breached, instead of photocopies of it, we have verifiable photocopies of it. It's great for onboarding. It actually is useful. It does increase security, but it does not get rid of this honeypot, right? So for those of you who have your data in whatever succeeded the OPM system, DISA something, I don't remember. Congrats, that data plus the finance data will be now verifiable when it gets stolen.
Sure. And Ross, Laz, are there any other proposals other than your own that you feel like are worth recognizing or also same question, find problematic in any way?
We've had a couple of other organizations that we've been going back and forth with and discussing our various submissions. If I'm completely honest, I have been focusing on ours, and so I haven't gone into deep detail on others' submissions. But I do know that the Decentralization Research Council is planning on submitting one, and I think it's in good shape. I know Andreessen Horowitz Crypto, I believe, is also submitting one too. So things to look out for.
Yeah, I haven't read other comment letters. I did read Ian and Peter's report, though. Thought it was great, so eager to read that letter. But yeah, aside from that, no.
Sure. And then I'm also curious, like, are there any NIST standards? If you guys don't know, that's the National Institute of Standards and Technology, which, as it sounds, develops standards for these types of things that apply here. Like, are there any kind of, boundaries, I guess, set by those standards that we need to be aware of?
This is not entirely my wheelhouse, but NIST is, especially through their National Cybersecurity, NCCOE, National Cybersecurity Center of Excellence, I think, is what it stands for, has been working on developing standards for digital identity and digital identity proofing, and so there is some work going on there. And then I think, just more broadly speaking, NIST does plenty of cryptography work as well, and so just sort of as a base layer, there's important things happening there as well.
Yeah, so there's both a good thing and a risk here. So NIST is, by my understanding, one of the people, or the people, standardizing the formats for digital identity for MDOC. I could be wrong on that, but and I would imagine those standards are going to be used in the simple sense of there's the standard, and someone's going to say, look, if you're a financial institution, you will take that standard issued by states. There's not going to be a question of who can issue it. It's going to be these states with these public keys, and that'll be your verifiable credential. I think that's likely what will happen. There are two things to keep in mind, though. One, that could easily end up with a thing where it's tied into particular mobile platform manufacturers, Google, Apple. So if you're one of the more decentralization, Ethereum, Bitcoin, Zcash people in the room, you maybe want something a bit more open than that. If you're on the TradFi side of the world, you probably are fine with that, but I'll just flag that as a thing. The other side of this, though, what's going to get interesting is if people start demanding more standardized cryptography for, say, privacy-preserving smart contracts, right? Aztec, Aleo, Miden, all these people are designing compliance mechanisms. And standardizing that in any reasonable time is going to be very tricky because the technology is moving too quickly. So I think you get standards for identity. They will probably be used, but that's not the privacy side of it. That's the verifiable, the thing in the honeypot that gets leaked is a verifiable credential, not a photocopy of your passport.
For the people who don't know, can you just define like verifiable credential as well? I don't know who all in the audience is up to speed.
Sure. So a verifiable digital credential is basically a set of claims about an entity. So, my name is Ross Schulman. I was born on such and such a date. Yada yada yada. Signed cryptographically by some entity that is known as an issuer. That can be your friend Bob, or it can be the state of California. It doesn't matter. It matters for whoever's going to rely on the credential when the time comes. But and I think the other salient kind of data point about them is that through fun cryptography, we are able to present only part of the credential to someone who's relying on it, and usually the quintessential sort of example here is your mobile driver's license will have a field in it that says is over 21 check mark or not, and you can again using in such a way that the relier can cryptographically prove that the state of wherever says I'm over 21 can get that piece of information and only that piece of information. Doesn't have to have my name, my address, or anything else in it. So it's called selective disclosure. And yeah, that's the short version.
Yeah. So the reason I had you go is that is the technically correct version, and I would have given a far too short spiel. But the way to think about it is take the barcode that's on your passport or the weird barcode on the back of your driver's license And imagine they took that and literally put a digital signature on the information, and you can submit that over the web and someone can look at it and verify that it's genuine. And you should think of it in those terms, not the selective disclosure, because for KYC for a bank, the selective disclosure is going to be you have to disclose everything. So it's just literally, we know you didn't Photoshop a passport. It's verifiable. So that's the abstract over the cryptography version.
Okay. And then just kind of for the last section, I guess, of this panel, I want to kind of address like developers. I don't know how many are in the room. I'm sure there's some also watching on the live stream right now. And obviously, like, they are the people kind of building a lot of the technology that we're talking about at the end of the day. What is the takeaway for developers that this RFI exists, that Treasury is looking into it? Is there any more safety or, I guess, protection or leniency to develop and experiment with these types of tools? What should they feel comfortable building versus what might be crossing a line somehow when it comes to building privacy technology today? I'll go to Laz because DeFi Education Fund, this is kind of your wheelhouse.
Yeah, I mean, that's like our core mission is protecting developers and their ability to publish software. And so, the RFC is really just pretty straightforward, just an RFC. I think for developers, it's like this is an ongoing battle that's happening in Washington, is just like ensuring that there are developer protections. And then also, it is just an RFC, but in the event that like there's a rulemaking that mandates that smart contract developers would need to change their software to meet some of these things, we really think that software developers should have the freedom to not be coerced into that. I mean, I could get into this third-party doctrine stuff, but really it's just like we want to protect the freedom to innovate. So there's not like any direct implications with the RFC, but it is our mission to make sure that people have that freedom and are not wrongfully prosecuted by the law, as we've seen. And so, yeah, that's.
I mean, like you said, people have been, as you're defining it, like wrongly prosecuted by the law. Should they still be worried that will continue to be the case, or?
I mean, we want to make sure there's like legislative fixes, and so like the draft that came out of Senate banking had the section on developer protections protected developers not just from registration requirements for money transmitting, but also protected them from just not being deemed money transmitters under Title 18, Section 1960, which, if you don't know, is what was used to prosecute the Samurai Wallet developers as well as Tornado Cash.
Do either of you have anything to add? I'll just add a little bit of backstory that you should definitely double check because I'm not a lawyer. So context here is FinCEN, the Financial Crime Enforcement Network, released guidance a number of years ago that said that developers of, what did they call it, virtual anonymity software, there's some term of art, were not, if you just write software, we're not money transmitters. And a lot of us sort of breathed a sigh of relief when this happened because we were doing that. People I knew were doing that. The Zcash folks were doing it. And then a number of years later, if I recall correctly, the Department of Justice decided to prosecute, among other people, the Tornado Cash developers, and literally said, we don't care about that guidance. And so that is still the state of play, and Genius Act, as far as I've been told by anybody, does not fix that.
No, if I just may add to that. No, he's absolutely right. There was the FinCEN 2019 guidance that people depended on. DOJ took a different interpretation, which is why we need to fix this through legislation. DOJ's interpretation for Tornado Cash and Samurai Wallet was basically that guidance only applied to the registration requirements under Title 31, and that is different than Title 18, which is about like the criminal. It's the criminal statute. It's like punishing you for running an unlicensed money transmitter, and so they interpret that as two different things, and that's why we need legislation to clarify that.
Sure. It looks like we have some time for questions. Does anybody in the audience have questions?
I'm way downtown. Here we go. Carol, what's your question?
I'm waiting for the mic. Thank you. I'm a little bit confused, honestly, about this panel because the title's Genius Act and Privacy and AML, and I think what I'm hearing is, sort of that ongoing confusion. I think there's been different threads. So it's been a very interesting conversation. I must admit that I got stuck on Laz's early comment about DeFi, and the real risk is cybersecurity, as opposed to thinking more broadly about the anti-money laundering issues and what other types of illicit finance type issues arise with respect to DeFi. I think looking at the issue around what is this RFC, request for comments, about, it really was intended to be a step forward in trying to get FinCEN and Treasury to consider the evolution of the technology and how we can move forward on some more enlightened types of approaches to anti-money laundering compliance. I know a lot of it has been focused on the identity issues, but identity is really just the very first step in anti-money laundering compliance. And I think one of the speakers in the last panel, and Ian has certainly picked up on this concept that there is more to just capturing the here and now of identity. So I guess maybe you can help clarify a little bit here. Are all of you really focused in the context of this RFC on the identity piece of it, or are you looking at the broader range of kinds of tools, certainly the blockchain analytics tools and so on, that come into play that are going to ultimately change how we approach AML compliance?
Yeah, just to answer your question, with the cybersecurity, I think we all know that the hacks are pretty fundamental to how money even gets into the hands of illicit actors. And so it seems pretty core to just have really strong software. And these some of these hacks too aren't even too sophisticated. I know Seal did a really good blog on the Bybit hack, but also just North Korean hacks in general, or cyber attacks are just nothing too sophisticated, nothing that's not used outside of DeFi. And so we're if you really want to mitigate illicit activity risks, then you should probably address this serious concern. Because it's also true in TradFi. And then with the digital identity, it's, we just came at it from the angle of, if your intention is to mitigate illicit activity risks, here are some risks that exist with identity and information collection that, in our opinion, enable illicit activity in a lot of ways. So in traditional finance, to Ian's point, the two hacks that he mentioned were the people vulnerable for espionage, right? The Chinese targeted these people for a specific reason. But they also, which I got from a FinCEN report, talking about how a lot of illicit actors use identity to drain people's funds or use it to commit fraud and move money in their name. And so when you're thinking about illicit activity, for me, it seems that information collection has been advantageous to them. And so we should kind of reconsider how do we address AML that doesn't necessarily require these massive honeypots, which requires a lot of innovative thinking. But that's an ongoing conversation that we're having with Washington and trying to find a good solution.
Did either of you have anything to add to that, or?
I think I'm speaking for myself. The Treasury Department RFC, I think split their questions up into 4 buckets: AI, APIs. God, I'm blinking. And then the last one was digital identity.
It's APIs, AI, digital identity verification, and blockchain technology.
Blockchain, right? I don't know how I forgot blockchain. And being a digital identity company, obviously one of those 3 is one of those 4 is more interesting to us than the other 3. And so that's sort of the context in which we're looking at it right now.
Yeah, and to answer your question, obviously, I'm definitely not focused on identity. That's one starting signal, and it's not a very good one, and you need a better system. I'd actually go one step further and say there's an open question. If the major problem you have for DeFi and tokenizing real-world assets going forwards is the existing KYC AML regulations and applying those, They're, according to the UN, like 1% effective. So that's not that hard to maybe get something that's 1% effective on a blockchain. Or if the larger thing from a US policy and national security perspective is nation-state actors stealing money, right? Particularly as like TradFi starts settling quicker. Because the Lazarus Group started out trying to hack SWIFT. And it moved so slowly that even when they got like a confluence of 3-day weekends in 2 or 3 different countries, they still got most of the money grabbed. And this is apocryphal, I don't think it actually happened, but I imagine somebody in a meeting after the fact went, wait, we could just do this into blockchain stuff, which settles quickly, and we won't get our money stuck in a casino in Indonesia or wherever it was. And so at least when I talk to people in DC, or, well, Maryland, most of the things they're worried about is cybersecurity risks because they're worried about the Iranians and the North Koreans. And that's like a new problem we haven't had to deal with traditional KYC AML, even in TradFi. It just settles too slowly.
I think we have time for one more. Yeah.
Hello. So you guys kind of discussed how Genius doesn't really get into any nitty-gritty details regarding like AML compliance in a decentralized system. It really kind of just defines exemptively something like RPC node providers, where indefinitionally they're not having custody or control over these assets. Now there's different providers that affect that with the data that they, are pulling that necessarily could change that. But if you take someone who runs like, I don't know, a relatively lean operation like QuickNode, where they're just, to my understanding, running just the transaction through an RPC node to the endpoint, peer-to-peer. If I'm the government, that seems like the perfect place, RPC node providers, to have some sort of AML compliance just required, even if it doesn't have anything to do with custody and control. Maybe it's on a privacy angle. So I was just curious if you all saw how kind of compliance would develop in this RPC node provider, excluding that they're not an issuer under Genius, and just offering this transmission value, not custody or control.
So again, not a lawyer, you definitely should talk to one. Genius, from my understanding, just says issuers have to KYC who they're giving the stablecoins to. It doesn't say anything after that about peer-to-peer transactions. And so that leaves you in this interesting mode where you can do a bunch of stuff to try to prevent bad actors or not care. And Genius doesn't care. That doesn't mean you're not legally responsible under something else. Opinions between DOJ and FinCEN evidently differ on that one. But I would imagine, the reason I want to point this out is I think that's actually where the innovation is likely to be here. It's not going to be in the KYC for issuers to the original people who get a stablecoin when they withdraw it. That's going to look like traditional banking KYC with verifiable credentials. That's my guess. It's the stuff that happens after that to do dynamic fraud prevention and reputation and such, so that you don't get enough bad actors with P2P stablecoins, that at some point later somebody either passes laws to stop that and put requirements on, or goes and reinterprets stuff so they can prosecute people even though they said they were exempt, right? Just to make a larger point, everyone here seen Die Hard? The original Die Hard, like good Christmas movie, right? The premise of the original bit of it is they're stealing bearer bonds. Those went away. Effectively speaking, they're coming back in a certain sense, and this is the actual problem you have, right? It's Hans Gruber trying to get in steal stuff, except he's doing it with a laptop. And that's the problem you really have to deal with.
Awesome. Let's leave it there. I think we're out of time. Perfect place to end it. Thanks so much.